Thank you for joining us this morning. We are honored to welcome to Berkeley Law the chair of the Federal Trade Commission, Lina. I don't think she needs an introduction to most of you, but I'll introduce her briefly anyway. As a law professor, indeed, as a law student, take note, Lina wrote articles that challenged and changed decades of orthodoxy in antitrust law. As chair of the FTC, she has galvanized efforts in the Biden administration to take on tech giants and other industry players in pursuit of a fairer marketplace in competition and consumer protection. The cases she is leading have the potential to affect the lives of hundreds of millions, indeed worldwide billions of people. She is the youngest chair in the history of the FTC, and though, according to our ACE researchers, not the first to be born in the UK, she is, we believe, the first person to give birth while chair of the FTC. Most importantly, she is the first chair in half a century to be working to energize and change the perspective and approach of the Commission. She has been called in the press one of the most powerful regulators of American business and the most feared person in Silicon Valley. She is, in short, that rarest of people and antitrust, consumer protection law rock star. Friends, please welcome Lina. So I will ask for about half of our time here, which is 45 minutes, a number of questions to the chair, and then we will open it up for questions from you. So, Chair Khan, the FTC recently filed a case against Amazon for engaging in monopolistic practices. 6 years ago, you observed in a seminal law review article that decades of narrow focus on high prices as the main indicator of monopoly power had left the legal and policy world blind to the ways that online platforms were gaining chokeholds on the digital economy. So, one, how does the interpretation of antitrust law need to change in order to address big tech companies' practices? What exactly does the FTC believe needs to be changed at Amazon, and how, if those things do change, will it affect all of us?
Well, let me just say, first of all, it's such an honor to be here, and thanks so much to Ted and Ben and others for putting this event together. It's such an incredible honor to be at the FTC at this moment, and it's such a unique moment in our country for kind of thinking about the ways that law and policy is so critical to shaping a fair economy and making sure that people get a fair shake in our economy. I also want to give a shout out to Professor Graywall, who's in the audience, and I had the honor of studying under while in law school, and he was just such a key part of how I go about thinking about economic power. I know he's not teaching this year, but highly recommend taking any classes with him. I also just want to share a little bit about how I got into this work, because when I was in law school, thinking about antitrust and corporate power was not as central as I think it's become, even in the last few years. And I really got my start in this work as a business reporter and journalist, and one of the first industries that I studied was chicken farming. And chicken farming, like many markets in the US, is structured somewhat like an hourglass. So you have millions of consumers on one side, thousands of farmers on the other, and they're all just connected by a handful of companies. And what that means practically is that if you're a chicken farmer in the United States, oftentimes your livelihood depends on a single company. And talking to these farmers, it became clear that that deep asymmetry of power between these chicken processors and these chicken farmers was leading to all sorts of abusive practices. And in the extreme, I saw how that concentration of economic power was also actually undermining fundamental liberties. So a decade ago, the government was interested in studying the evolution of trends in the chicken industry, and they held all these workshops across the country, and they asked chicken farmers to come share their experience. And during that time, these chicken companies actually threatened the chicken farmers and said, if you go and speak to the feds, we're going to retaliate against you and cut you off. And so out of fear of retaliation, you had these chicken farmers that wanted to speak to the government but couldn't. And for me, it was just such an important moment in recognizing the ways in which concentrated economic power can undermine liberties like free speech. I think oftentimes, in law school and in discussions about free speech values, we think about government infringement on those liberties, and here was just such a clear example of how concentrated corporate power can also infringe those liberties. And I think just more generally, thinking about the role of economic power in whether we really have real freedom in this country has been a key part of the current anti-monopoly moment, and I think what's really animating a lot of the reform that we're seeing right now across the administration. The Amazon case that we filed a couple of months ago is a key part of that effort, and we allege that Amazon engaged in a whole set of anti-competitive practices to really shut out competitors from the market. A key part of the complaint is really about how competition works in digital markets today. So to really compete in digital markets, you need a key level of scale. You have to build a critical mass of customers or a critical mass of merchants to be able to benefit from the accelerated growth that digital markets can provide. And what our complaint lays out is that once Amazon itself was able to establish that scale, it engaged in all sorts of tactics to make sure nobody else could achieve that similar growth. And we allege that there are real harms to this. There are harms to the merchants that are entirely dependent on Amazon. Amazon's been steadily hiking the fees it charges merchants. So on average, it now takes close to 1 out of every $2. So merchants pay effectively a 50% tax to Amazon. We also allege that it's been raising prices for consumers, degrading search results, degrading the overall quality of the platform. And if in an ordinary, open, competitive, fair market, if you have a company that's hiking prices for its customers and making service work, that's exactly the type of situation when you would expect competition. But our lawsuit lays out that because Amazon has kind of cut off those key avenues of competition, it's now able to exploit its monopoly power with impunity. So that's what the lawsuit is about. We're at this stage focused on establishing liability, but we make very clear to the court that an antitrust remedy is supposed to not only halt the offending conduct, but also fully restore competition. And in a market like digital markets where the relationship between the anti-competitive practice and the harm is not one-to-one, it's exponential, these harms really accumulate. You have these feedback loops of data and scale, and so fully restoring competition in this market, given Amazon's anti-competitive tactics, could require pretty significant intervention. And we say everything should be on the table, including structural relief.
So let me ask you this. You've had a series of setbacks with cases brought by the FTC against other tech companies, other large companies. This is just much of them in just the past year. Is that causing you to change tactics, or is there a sense that we're going to keep trying because we have a new theory courts may not be as well acquainted with, or is there indeed a reason to be bringing these cases other than simply prevailing in a judgment?
So we only bring cases where we think there's a law violation and where we think we can win. And we've had a whole set of successes on the antitrust side as well as on the consumer protection side. On the antitrust side, we've lost so far 2 cases out of overall, close to 20 abandonments in the merger context, a whole set of conduct cases that are ongoing, a whole set of really favorable opinions. And in those 2 cases, one was Meta Within, the other was Microsoft Activision, which is still on appeal. And so anytime we have these setbacks, of course, we look closely at the opinion, figure out, what could we have done differently, done better. The Meta Within case was a case where we were looking to apply potential competition doctrine to digital markets, which can be a challenge, right? Because in order to be able to allege potential competition, you're often trying to show competition at very early stages. And a lot of the traditional tools that you use to assess and analyze competition in smokestack industries just aren't as probative in digital markets. And so you're in real time having to either come up with new analytical tools or look for evidence that's just not going to look the same as it does in other cases. So, we brought that case because we thought there was a law violation. We didn't ultimately prevail in getting a preliminary injunction, but a whole lot of the analysis that the court did was actually very useful. The court affirmed that the potential competition doctrine is alive and well. It applies in digital markets, which Facebook was alleging it doesn't. He also gave a lot of very useful guidance about what you need to show potential competition successfully, and ruled for us on things like market definition, which can be quite critical. So obviously we wish that had gone another way, but all things considered, we think it provided a lot of clarity in the law, and also I think creates a roadmap for us to build on in the future.
All right, well, let me do something I probably should have done at the beginning, and just introduce myself. My name is Ted Mermin, and I run the Center for Consumer Law and Economic Justice here at the Berkeley Law School. So since I run the Center for Consumer Law over on the, which is more on the FTC's consumer protection side, it is incumbent upon me to ask you, so what is the FTC doing on the consumer protection side these days? And particularly, how is it different from what the FTC might have been doing in previous administrations?
So the consumer protection side, we're very, very active. Kind of philosophically, one of the things that we're doing is looking at our key authorities in a way that we think is more honest and faithful to what Congress intended for us to do. So Section 5 of the FTC Act prohibits unfair or deceptive acts or practices. And we think that applying that faithfully in the digital age is going to look somewhat different than what it did, 10 or 20 years ago. And, there was a move in the late 70s and early 80s to view the goal of consumer protection as fundamentally about making sure that rational people have all the information they need to make their rational decisions in the world. And so the primary focus was on preventing deception, preventing fraud, the idea being that if you just make sure that people are not getting dishonest information, that everything in the market is okay. And so it was a fairly limited role for government. We've been focused not just on what deception looks like, but also what unfairness looks like in the modern economy, and have really been focused on things like data privacy, the fact that all too often to use services that are essential for navigating day-to-day life, people have to surrender all sorts of sensitive data. And that in those types of instances, they might not actually be exercising real choice. And so we've been very assertive in explaining how unfairness applies in these new contexts, and said things like, if companies are collecting data for the purposes of providing health apps, you can't then use that sensitive health information and sell it or make it available to third parties. We have a case against Kochava that's ongoing relating to people's sensitive geolocation information. More generally, I would say, though, we're also looking to activate all of our statutory tools. And so we're doing not just case-by-case adjudication, but also a whole set of rulemakings. Partly that was spurred by an unfavorable decision that the FTC got from the Supreme Court before I arrived in the AMG case, where the Supreme Court said that Section 13B of the FTC Act is not a basis for getting monetary equitable relief or disgorgement. And so what that meant was that the main statutory tool that the FTC had been using to get money back for people when companies are illegitimately taking that money was suddenly gone. And so as a result, we've been activating our rulemaking tools, because if you have a rule violation, you can actually get redress, you can get civil penalties. And so making sure that we are not allowing companies to profit from illegal conduct is really critical from a deterrence perspective, and so our rulemaking is a key part of that. So we have rules making underway related to fake reviews. We have a rule that requires companies that make it as easy to cancel a subscription as they do to sign up for one. We have a proposed auto rule that would prevent bait and switch tactics by auto dealers. We have, close to, I would say, a dozen rules in the consumer protection space that are ongoing. To do these rulemakings, for the most part, we don't follow the Administrative Procedure Act. We follow something called the Magnuson-Moss procedures, which are heightened. So all of it can take much longer, but we think it's absolutely critical if you want to deter lawbreaking in the first instance to actually make sure companies can't profit off of that lawbreaking.
Okay. The flavor of the month is Gen AI. Maybe it's the flavor of the next decade. We'll see. On Monday, the Biden administration issued an executive order on the subject. You have written, although these tools are novel, they are not exempt from existing rules. Are existing rules sufficient to regulate AI? And if not, what should regulatory agencies and Congress, and perhaps even forward-looking legislatures like that here in California, be thinking about?
So look, AI poses a whole set of questions. Gen AI is a subset of that. And there are a lot of really interesting and important conversations happening about, what more is needed, be it from a safety and security perspective, be it from an election integrity perspective. We at the FTC are focused on, competition and consumer protection. And from that vantage point, we want to make sure that it's absolutely clear that there's no AI exemption from the books. I think there's a recognition in DC that there was a missed opportunity with Web 2.0. That there was a sense at that point that the best thing for government to do was just to sit back. And now, 2 decades on, I think there's a real recognition that business models that are premised on endlessly vacuuming up people's people's sensitive data, or social media companies that are, according to various lawsuits, engaging in practices that is detrimental for people's mental health, allowing acquisitions by companies that allowed them to protect their monopolies, that there were all of these business practices that, had government acted earlier and sooner, would have put this technology in a more healthy trajectory. And so I think that experience is leading Congress and enforcers and the administration to make sure that we don't replicate some of those missteps. Obviously, with AI, things have the opportunity to move much faster. And so the EO laid out a whole set of requirements and suggestions for agencies across the board, including for the FTC. And for us at the agency, we're not focused on some of the existential risk and the moral panic, which I worry sometimes can distract from the more immediate problems. We're already seeing in our complaints database, people noting how these voice cloning tools are being used to scam people out of thousands of dollars, right? So people call up elderly Americans pretending to be their grandkids and saying, hey, your grandkid's in trouble, we need thousands of dollars. That's already happening. I think we've also seen how some of these AI tools can be used to turbocharge fraud more generally, since they can be used to disseminate scams much more cheaply at a much broader scale. So those are the immediate harms we're focused on. From a competition perspective, we're really scrutinizing the entire stack and figuring out, are there layers here where we're already seeing bottlenecks, already seeing potential monopolization, and how do we make sure we're staying vigilant?
So getting in at the ground floor, even from the competition side, before the monopolization happens?
Yeah, look, some of AI requires inputs that are already somewhat concentrated, be it at the chip level, be it at the cloud level, be it at the compute level. And so some of those bottlenecks are already there. Some of those are currently being addressed through things like the CHIPS Act and other efforts to inject more competition. But more generally, I think we need to be thoughtful about, what are the layers where we're likely to continue to see significant concentration. That might be because just economic properties of how those technologies work. But at the very least, how do we make sure that concentration is not being used to coerce actors across the supply chain or condition access to your base model premised on, extending your cloud contract, or forms of illegitimate ties or coercion that we've historically seen firms that monopolize a key input are able to use their power that way.
All right. Let me ask you one more question, and then we will turn it over to the audience. It was not so very long ago that you were sitting in those seats in law school. You've spoken a little bit about how you got here, but let me ask, how did you get from there to here, and what advice or thoughts might you have for the law students of 2023?
So I had a somewhat, unusual backdoor way into being interested in antitrust. And when I was in law school, I took antitrust, but more generally was just interested in the different areas and bodies of law that shape corporate power. So in addition to antitrust, was thinking about, corporate law, trade law, First Amendment law, since First Amendment has become a key deregulatory weapon. So try to get insight into what are all the bodies of law that are ultimately responsible for the shape of corporate power that we see in our economy today. After law school, I kind of returned to kind of independent research. I was due to clerk a year out, and so was spending a year, returning to some academic research. My judge ended up, unfortunately, passing away, and so that kind of scrambled my plans, and I ended up deciding to work at the FTC for a commissioner who had just been confirmed, Rohit Chopra, who now heads up the CFPB. And that was a really fantastic experience to just be at the antitrust agency and just see all of these tools that Congress had given the agency that at that moment in time were not being fully used. And so I spent my time at the agency really trying to understand the full scope of statutory authority that the FTC had and what it would look like for it to more aggressively wield those. After that, I ended up going to join a congressional committee, the House Antitrust Subcommittee, which had decided to launch an investigation into digital platforms to try to understand, what are potential competition problems here. And that was appealing to me because Congress used to play a really, really central role in debates around antitrust and anti-monopoly. And one of the tools that they had was to do these really deep investigations. There was a whole set of investigations into, just understanding how various markets were working. And this was a tradition, through mid-century. And so the opportunity to kind of reinvigorate that muscle of Congress seemed like a really great chance. More generally, though, I thought it was important for Congress to reassert itself in the antitrust domain. I think one reason why over the last few decades we saw a more hands-off approach to antitrust was because it was allowed to become much more technocratic and arcane. And so the connection between decisions that antitrust enforcers were making and real-world effects in our economy relating to, drug prices or healthcare just became severed. And so reasserting the role of Congress in antitrust discussions and debates also seemed a key way to re-democratize what antitrust is about. And so that was a really fantastic experience. After that, I ended up joining a law faculty at Columbia, teaching antitrust and anti-monopoly, and then had a chance to serve in this role.
All right. Well, let's open it up. We have people with microphones. Please raise your hand if you have a question.
Hi, good morning. Thank you, Chair Khan, for being here. I wanted to ask you if you're, from your point of view, if antitrust laws and doctrine should change or update to better address the issues arising from tech platforms as self-preferencing or the access to data. Thank you.
Yeah, it's a good question, and one that has certainly been top of mind for lawmakers. So in the last congressional session, there were a whole bunch of bills that were introduced to address just those things. There was a bill introduced to address self-preferencing by dominant tech platforms, another one that would have addressed the conflicts of interest that can arise when you have a firm that's both serving as a critical platform and distribution channel, but also competing with the entities that's dependent on it and able to do things like appropriate their data. So I think those legislative discussions are definitely ongoing. At the FTC, we're bound by the existing laws and the existing judicial interpretation. I do think that there's an opportunity to be continuing to explain to the courts how these foundational antitrust laws apply in some of these newer markets. I think one of the consequences of a somewhat dormant period in antitrust enforcement, especially around monopolization, was that you have parts of the laws that are somewhat calcified and doctrine that's premised on business dynamics in smokestack industries rather than in digital markets. So I think it's going to take some time and some back and forth between the agencies and the courts, but one reason why Congress wrote the antitrust laws as broadly and in general terms as they did was because they wanted them to be flexible tools that could evolve with markets. And so as enforcers, we're kind of bound to continue to push on that vision.
No.
So my question would be, you describe yourself as a new Brandisian, and you famously parodied Robert Bork and the consumer welfare approach in your Yale Law Journal paper. I'm wondering, what's your ideal for the competitive world? Are you looking at going back to for example, the breakup of big companies like AT&T or John Pierpont Morgan in the earliest century, or are you thinking about taking a more creative approach in this more digital era?
So look, I think there are a lot of really important academic conversations and debates about, in an ideal world, what would the antitrust standards look like? At the FTC, we're really focused on how can we be most faithful to what Congress asked us to do. And interestingly, the FTC Act, which was passed after the Sherman Act, and in part to fill some gaps, both in that law as well as in some jurisprudence that had developed interpreting the Sherman Act, the FTC Act uses the language prohibitions on unfair methods of competition. And that language differs from what's in the Sherman Act and what's in the Clayton Act. And one of the key priorities of the FTC right now is to give meaning back to that term, unfair methods of competition, because embedded in that term is the idea that there are fair and unfair methods of competition, and that fairness is supposed to mean something in terms of forms of fair dealing in the market. And so that's what we've really been focused on. We issued a policy statement last year that sought to reinvigorate what Section 5 means. There had been efforts previously to collapse Section 5 of the FTC Act onto the Sherman Act and say, these are actually just the same, and we think that's wrong as a matter of fidelity to Congress. So that's really what we've been focused on, reactivating that tool, explaining to the courts what it means. Some of the rulemaking that we've done also leans on Section 5. So in January, we proposed a rule that would eliminate non-compete clauses in the vast majority of employment contracts, and that we determined that non-competes are unlawful under Section 5 of the FTC Act. So that's really been our focus, unfair methods of competition.
Okay, thank you. I was wondering if you could speak to how you see your efforts at the FTC and the Biden administration broadly fitting into the global antitrust efforts and the kind of global antitrust story.
Yeah, so it's a really interesting moment globally on antitrust, in part because I think enforcers around the world are seeing a shift in the US, right? And so international engagement by antitrust enforcers for the vast majority of the last 2 decades had basically been US agencies telling the rest of the world not to be so aggressive or not to be so enforcement minded. And there was a view that the US thought that other enforcers or other regulators were being protectionist when they did things like bring antitrust lawsuits against some of the tech companies. And so enforcers around the world are now sensing a shift in the US where we're saying we actually need to be more assertive, and there were missed opportunities in the past. And so it's been really interesting to have that conversation globally. There's a big conversation happening around digital markets, and a whole set of legislatures around the world have actually been introducing new policies and new regulatory tools to address the market power of digital platforms. But for a lot of countries, the digital platform conversation is interesting, but they're really focused on more bread and butter issues for people in their day-to-day lives. So, especially in the inflationary environment that we've seen over the last couple of years, how do we make sure that food and agriculture markets are adequately competitive? How do we make sure that concentration in supply chains is not leading to undue fragility? So when you have a particular shock or a pandemic, you're not seeing cascading effects where the entire supply chain seizes up and you have major shortages. And so those are conversations that are also ongoing right now. The administration more generally has been pushing what the White House and the president call a whole of government approach to competition, recognizing that antitrust enforcement needs to be reinvigorated, but that other agencies have important competition tools as well, be it the Department of Transportation, or a whole set of other agencies. And so we've been working closely with DOT, USDA, HHS, other enforcers and regulators to make sure that when they're using their policy tools, they're not implicitly or inadvertently allowing monopolization and are instead thinking about competition.
Hi. Do you believe there's any point where it's perhaps too late for a company where they've gotten so big, or perhaps they have such a large monopoly on the on their industry where it hasn't been spotted, or it hasn't, or no one's challenged it? And when you challenge that company, how do you scale them back if they're already so large?
Yeah, it's an interesting question, and there are a long history of different remedial tools that the agencies have used when they've gone after monopolies. So in some instances, the agencies have asked for and gotten structural relief. So breakups, be it of Standard Oil or AT&T. There have also been other tools like requiring companies to open up their patent vaults. And so one of the consent decrees that the Justice Department reached with AT&T in the mid-50s actually required Bell Labs to allow licensing, free licensing of its patents, which ended up spurring a whole set of innovation. So there's a history of what agencies have said is needed to fully restore competition. Oftentimes in those types of instances, competition ends up coming from technological developments and technological advances. And so that's why in moments of technological inflection points, it's especially important to not allow the incumbents to use their monopoly power to thwart new entrants or thwart new competition that's coming in through some of these new technological innovations. So the case against Microsoft that the DOJ brought in the late 90s was designed to do exactly that. There was this technological inflection point. There was a view that Microsoft's tactics were threatening to deprive Netscape and others of the oxygen they needed to really compete and inject competition and loosen Microsoft's grip on the operating system market. Similarly, the lawsuit that the FTC brought against Facebook alleges that as the market was shifting from desktop to mobile, Facebook felt threatened, and they tried to organically compete but weren't able to succeed, and that's when they went out and made these defensive acquisitions of Instagram and WhatsApp as a way to maintain their monopoly through the technological transition point that, but for those acquisitions, would have injected more competition into the market. So generally speaking, being very, very, very vigilant at those technological inflection points is often one of the best ways to promote that competition.
It's sort of like a follow-up of the global approach question. Like we've seen, central bank executives and finance ministers does have platforms to coordinate their actions, so to speak. Do you see a potential is there that sort of platform to coordinate actions between competition commissions across the world in terms of engaging with these multinationals in terms of timing of lawsuits and then actions and so forth?
There's certainly a lot of engagement internationally, but ultimately, because at least in the U.S., antitrust is a law enforcement regime, we're limited by what our authorities allow us to go after, and so we only bring cases based on the specific facts and how our law applies to those facts. But there certainly are information exchange agreements, cooperation agreements. A lot of my Republican predecessors at the FTC actually were really keen on building a lot of those international relationships and making sure that the FTC was at the frontier of the international antitrust conversation. And so we have a very robust program in place to do that type of information exchange where we have agreements. But that's generally speaking the extent of it. We're not really able to coordinate on lawsuits per se.
Thank you. The new brandeism have a few fundamentals. One of them is you condemn monopoly power per se. However, in the complaint of the 26th of September, it's more like it's a complaint about the acquisition or maintaining the monopoly power. And the second fundamental is you promote harm to the competitive process, but the complaint was more about consumer welfare standard. The third one is you denied a little bit the effect, the short and long-term effect of prices, but the complaint focused on the effect on prices and raising rival costs. Is this evidence that the new brand deism is failing and it was more like an utopic idea or what some people call populist antitrust? And my second question is, if you want to answer this, and then I ask the second.
Let's do one at a time first.
Okay.
So one thing that's interesting about monopolies in the digital age is that you see a life cycle. You see tactics that firms use in their early years to really chase growth over profit, because the network effects and the feedback loops of data really incentivize trying to capture the market as much as possible, because you have those more natural entry barriers, and then the companies can erect additional entry barriers to protect their position. And so companies will engage in a particular set of tactics when they're in that phase of the platform playbook. What we see at later stages is once companies have successfully come to dominate the market, erected all sorts of entry barriers, they shift to extraction mode. And so that's when companies are able to start hiking prices, worsening services. You kind of see how they can become too big to care. Cory Doctorow is somebody who's written about this very eloquently and has a term of art that he's come up with to describe this life cycle and the kind of degradation that you see by these dominant platforms once they've locked in customers and come to protect their position. So when thinking about what type of, if you believe there are law violations, what should be the practices you're focused on, we wanted to focus on the practices that are most relevant at this moment in time, that we believe are central to how the company is maintaining its monopoly right now. And so there's no doubt that if enforcers had investigated a decade ago and determined that there were practices that were illegal a decade ago, those would have looked very different. And those might indeed be some of the ones where it may be harder to bring a case under current jurisprudence. But I do think both with the Amazon lawsuit as well as with the Google lawsuits that the DOJ has brought, you really see how these firms are at the later stage of the monopoly life cycle, what they've been able to enter extraction mode with impunity. And it really goes to the heart of what the antitrust laws were designed to prohibit.
Thank you, Chair Khan, for this amazing talk. It's clear that you've had a very distinguished career from law student to faculty member and now chair of the FTC. I had a bit of a more broad question. So I'm curious as to how your perspective on antitrust policy and consumer protection policy has sort of evolved over the years, if at all, through the experiences and understanding that you've gained.
I think in this role, I've just become much more attuned to some of the practical challenges of bringing the lawsuits. So things like, when you're doing a merger investigation, the companies have more of an incentive to move the investigation along because they want to close their merger, right? They want to get the thumbs up and be able to go forward with their deal. When the FTC is instead doing conduct investigations, so Section 2, Section 5, antitrust investigations outside of the merger context, we've seen they really don't have an incentive to produce information or do anything other than really delay. And so they're just practical obstacles to being able to bring timely enforcement actions because companies' incentives to cooperate with producing information and evidence are just not there. So that's one practical challenge that we've seen. Another thing about antitrust cases is that they've become extremely expensive. And so as antitrust analysis has become much more dependent on certain types of IO economics, the defendants are going to hire their economic expert, and so antitrust agencies also have to hire their economic expert. These economic experts are very expensive. I mean, the agency routinely spends millions of dollars on them, and you kind of see an arms race to kind of hire up these experts. The government, of course, is limited in what it can spend. But the one thing that we've seen that seems quite perverse is, both the defendants and the plaintiffs are hiring these economic experts. They're going to court. The experts are kind of, explaining to the judge what their models are, how they're assessing harm. And there have been a whole set of instances where the judges have said, look, each of you has your fancy economist. I'm a generalist judge. I don't understand these models. At the end of the day, you kind of cancel each other out. And so I'm going to make my decision based on which executive I found more credible. And so you have these situations where the government is spending millions of dollars on this analysis that the judges are saying is just not probative and not useful to their analysis. And so that's one place where we just see an inefficiency and really sometimes a waste of resources. And so I would say just appreciation for some of those practical applications or mismatches is probably one of the major things I've come to see. The other thing is just how scarce resources are. I mean, the FTC, by some measures, is smaller today than it was in the 1970s, even though our economy has ballooned, right, like 15 times over. We have fantastic staff, very expert people who are just day in, day out fighting to protect the American public, but they're really overworked and they're really stretched thin, and there's only so much you can do when your budget is somewhat frozen. We've been very lucky to get budgetary increases from Congress over the last couple of years, and so we have been hiring and have been expanding, but all things considered, we're probably still a fraction of the size we need to be.
Hi, thank you so much for being here. My question is regarding the American Innovation and Choice Online Act, which seems like the equivalent of the DMA for the United States. Do you think that it does an adequate job in addressing the challenges of the digital markets? And do you think it's likely to actually get passed, considering the way that lawmaking has been recently?
I mean, I'll just say it's been so impressive to see a bipartisan group of lawmakers really get into the weeds of what are the challenges that we're seeing in digital markets and actually try to put together legislation to address it. That bill in particular, I believe, made it out of committee in the Senate and the House last Congress, and so there seemed to be particular movement and momentum around that. Unfortunately, Congress last session did not end up bringing any of the tech bills to the floor, so I think there was some disappointment there. But there still seems to be a lot of energy in both houses on a bipartisan basis to be addressing these issues.
Hi. So my question is that as far as antitrust procedures are concerned, they generally kick in if a certain player has a dominant position in a relevant market. But we've seen enough instances. I come from India. We saw that there were dominant players in certain markets which entered a new relevant market. And they weren't even considered dominant in that new market because they were just a recent player. But they changed the market completely. We saw Reliance entering telecom and changing the telecom scene completely in India. We saw Adani getting into cement industry and changing that. We saw Elon Musk getting into Twitter here. So what is the right time for the antitrust procedure to kick in? Is it the right stage when a dominant player from a different relevant market entering a new market, or should the antitrust authorities wait for that player to become dominant in this new market and then kick in the procedure?
So under the US laws, the Clayton Act is designed to halt concentration in its incipiency. And the statute overall was designed to address what Congress saw some of the shortcomings in the Sherman Act, which was that under the Sherman Act, lawmakers thought, it only allowed lawmakers to act once the firm had already monopolized a market. And one reason they passed the Clayton Act was to equip enforcers to address the problems at a much earlier stage. And so we just issued revised draft merger guidelines with the DOJ, where we lay out a whole set of ways that we would be reviewing transactions. One of the guidelines that we lay out is addressed to the fact pattern that you laid out, which is instances in which you see a dominant firm enter a market in a way that's maybe designed to entrench its existing power or extend that power. And so we think that's absolutely ripe for scrutiny and something that is prohibited already under the existing laws.
So let me ask you one last question, and that is, what is your message for law students today?
Well, look, I'll just say it's an incredibly important time in our country. I think there's a lot of contestation right now about the relationship between government and corporate power and private economic power. And so really just invite those who are interested to think about public service in this issue. The FTC is hiring. We just launched actually a new honors program that invites recent grads and fresh folks out of law school to come to the FTC and spend time both in our consumer protection division as well as our antitrust division. And it's a really important moment. We need you all. We need public interest-minded folks who are interested in using our laws in the ways that Congress meant to make sure we have a fair economy where people can compete and people are protected. So I really hope we'll see you all join that fight.
FTC Chair Lina Khan, thank you so much for joining us.
Thank you.